We will be covering the next article from the UPSC Essentials magazine by the Indian Express, the July issue. So this is a very important article related to 10th schedule and anti-defection law. In the Indian polity GS1 section, over years questions have come in the mains examination, prelims examination. Let us start. So how the 10th schedule regulates political defections. The 52nd Constitutional Amendment Act, so very important, 52nd Constitutional Amendment Act, this introduced the anti-defection law through the 10th schedule in 1985. So 10th schedule in 1985. So these two information is very important. I think MCQ can be based on these only. More than 4 decades later, why does the law continue to generate intense political and constitutional debates? See infographics for key insight they are saying. So in 1967, a Haryana MLA, Gaya Ram, he changed his party thrice within the same day. As per PRS legislative research, this infamous episode popularized the phrase Aya Ram, Gaya Ram in Indian politics to describe turncoats and defections. The following decades saw frequent defections, horse trading, and the collapse of elected governments. So you must remember that in 1967 there was a MLA of Haryana, Gaya Ram. He switched his political party thrice in a single day. So Aya Ram, Gaya Ram, that phrase became popularized. I remember in 2021 there was a question based on this as well in prelims. But defection is not just a matter of changing a party, it involves questions of political morality, judicial review, constitutional governance, legislative autonomy, and deliberative democracy. And how does the anti-defection law seeks to address these issues? So what is the rationale behind the anti-defection law? So let's say, let me discuss in brief. Let's say as a voter, we are voting a candidate, but sometimes our rationale is not to vote the candidate, but to vote the party. So sometimes we are unsure of the candidate, we don't know them, how their work would be, but we are sure that this party is great and it is going to push its candidates to work harder, and ultimately we will see good governance. So that is why at times we are voting for the party, not for the candidate. But then if the candidate who we voted is elected, switches his party, so that voters' right seems to be eliminated here. So that is the rationale. The 52nd Constitutional Amendment introduced the anti-defection law through the 10th schedule in 1985 to curb political defections. In his book Anti-Defection Law and Parliamentary Privileges 1993, the constitutional expert Subhash Sri Kashyap describes defection as the abandonment of loyalty, duty, or principle. So that is the definition of defection, that is abandonment of loyalty, duty, principle, or of one's leader or cause. The statements of objects and reasons of the 52nd Constitutional Amendment Act stated. So this is the statements of objects and reasons. The evil of political defections has been a matter of national concern. So it's a matter of national concern. If it is not combated, it is likely to undermine the very foundation of our democracy and principles which sustain it. The 10th schedule therefore aimed at establishing constitutional mechanisms to discourage such unprincipled practices. It protects the stability of the government and preserves the integrity of the electoral mandate. So constitutional mechanisms, so therefore the 10th schedule aims to provide constitutional mechanisms to discourage such unprivileged practices, to protect the stability of the government and to preserve the integrity of the electoral mandate. India's anti-defection law explained. So the Constitution 10th schedule. So when can a legislator be disqualified? Who decides and what have the courts said? 3 key dimensions of the anti-defection law. So when can a legislator be disqualified and who is going to decide that, and what have the courts said? Are there any Supreme Court rulings on the anti-defection law? Introduced in 1985 to curb political horse trading. So political horse trading को curb करने के लिए. So there are 4 grounds of classification. Let us see one by them. So 4 grounds of qualification. Under the anti-defection law, a legislator, whether he is an MP or he is a state MLA, he can be disqualified on any of the following grounds. The law applies to both parliament and state legislatures. He voluntarily gives up party membership. So he has voluntarily resigned from his party. need not file a formal resignation. The Supreme Court ruled in Ravi S. Naik 1994. Need not file a formal resignation is very important. Supreme Court ruled in Ravi S. Naik case in 1994 that conduct alone, such as holding, such as holding positions in another political party, can constitute voluntary exit. Votes or abstains against party direction, very important. So if a member votes contrary to the party whip without prior permission, so he voting contrary to the party. So whenever in the parliament there are multiple scenarios which appear when you are supposed to vote whenever majority is being decided. So if you are voting against the party whip, so votes contrary to the party whip without prior permission, and the party does not condone the act within 15 days, disqualification follows. Now independent joins a party post election. So a person who has fought the elections independently and has been elected, he joins a party post election, because the voter mandate is as an independent candidate we have elected him. So if he is joining a party, he is discouraging the voter mandate. So that is why an independently elected member who joins any political party after winning the seat is liable to be disqualified. The nominated member joins a party. Also a member who is nominated, he must not join any political party after 6 months of the taking the seat. So till 6 months they should not join any political party. So that is what a nominated can do. So 4 conditions we have seen: if he voluntarily resigns from the party, votes against the party whip or party directions, an independent candidate joins the party post election, and a nominated member joins the party within 6 months of their taking seat in the house. So there is one exception to disqualification. This is very important. So what is this exception? Let us see. So 2/3 merger is protected but splitting is not. So if there is a party merger which is happening, let's say two-thirds of the candidates of a party, they have formed a new party, they have merged with another party. So if the 2/3 candidates are moving out, then it is not called disqualification under the 10th schedule or anti-defection law. So a legislator escapes disqualification if at least 2/3 of the party's legislators agree to merge with another party. The original law also allowed a 1/3, so that is very important. So the original law, it allowed a 1/3 split exemption, but this was widely abused for mass defections. So the 91st Constitutional Amendment 2003, so very important, the 91st CAA moved this to 2/3. So remove the party split exception entirely. So only 2/3 mergers allowed, 1/3 split slot. So 1/3 split not allowed, only 2/3 merger is allowed. The same amendment also barred defectors from holding ministerial offices until they are re-elected. So such disqualified ministers cannot hold ministerial offices until they are re-elected. So let us see 10th schedule. Who decides? So very important. So the speaker decides, but is the speaker neutral? So let us see. Now the speaker decides, but is the speaker neutral? So this is part 6(1) of the 10th schedule. So the speaker decides, but is the speaker neutral? So the 10th schedule vests the power to decide disqualification petitions in the presiding officer, the speaker of the Lok Sabha or the state assembly, or the chairman of the Rajya Sabha in whichever house that legislator has been selected for defection. The decision was originally declared final, reflecting constitutional faith in the speaker as an impartial authority above the party lines. So he is the sole authority on disqualification. Number 1, only the speaker or the chairman in Rajya Sabha can decide whether a legislator has defected or must be disqualified. No other body has original jurisdiction. Very important. So no other body has original jurisdiction. So he is the sole authority on disqualification. Neutrality concerns in practice. So speakers are typically elected members of the ruling party. So this is very natural, and the bias can come because the speakers, they come from the ruling party. The ruling party leader or the prime minister can have a say on the decision of the speaker. So neutrality concerns are there in practice when we follow. Though the constitutional office is impartial, the constitution declares that the speaker is an impartial office, he is the leader of the house, but still there can be bias. So speakers are typically elected members of the ruling party. Allegations of political bias, particularly in deciding petitions against their own party rivals, have repeatedly raised questions about institutional independence, timing as a political tool. Now, speakers have been accused of deliberately delaying decisions. So, they have been accused of deliberately delaying decisions on the disqualification petitions, keeping legislators in limbo and allowing governments to survive flow tests. This timing question prompted direct Supreme Court intervention. So, let us say what the Supreme Court has said. So from no review to a 3-month deadline. So judicial evolution, very important. So I think in mains any question can come in which we are supposed to judicially analyze what have been the judicial pronouncements on the pronouncements on the 10th defection law or the anti-defection law. So the 10th schedule, from a no review to a 3-month deadline. So this is very important, you must remember. The 10th schedule originally barred courts from reviewing the speaker's decision. So the 10th schedule has originally barred Supreme Court from, because the sole authority or the jurisdiction only lies with the speaker or the leader of the house. Now, 10th schedule originally barred courts from reviewing the speaker's decision. The Supreme Court has since dismantled that shield through a series of landmark rulings spanning 3 decades. Now, the first case that is very important that came in 1992 is the Kihoto Hollohan versus Zachillhu case. So, 1992 Kihoto Hollohan. So the judicial review is restored. The Supreme Court upheld the constitutional validity of anti-defection law but struck down the bar on judicial review. So very important, it struck down the bar on judicial review. So judicial review is restored. It upheld the constitutional validity of the anti-defection law. The court held that speaker acts as a tribunal under the 10th schedule and judicial review is part of the basic structure of the constitution. It cannot be bypassed. So judicial review of tribunals is allowed, and in this case the speaker is acting as a tribunal while deciding anti-defection cases. Then in 1994 came the Ravi S. Naik versus the Union of India, which we discussed very shortly. So in the Ravi S. Naik case, they said that you don't have to resign, a formal resignation is not required, and only a conduct based while like holding positions in other parties, etc. is also. Conduct equals defection, they're saying. So the court ruled that a formal resignation from a party is not necessary from disqualification, and inference of voluntary exit can be drawn from a legislator's conduct, such as joining positions in a rival party even without a written resignation. Then came 2016, this is Nabam Rebia versus the Deputy Speaker case, important one. So, Speaker cannot act under a cloud. The court held that a speaker who is facing a pending notice of removal cannot decide on disqualification petitions. So it said that speaker who is himself facing a pending notice of removal cannot decide on disqualification petitions. It significantly constrained the speaker's powers during moments of political crisis, the very moments when defection cases most commonly arise. Then came 2020, which is Keisham Meghachandra Singh versus Speaker in Manipur. The 3 months deadline is recommended, so very important. So this is the Keisham Meghachandra Singh versus Speaker of Manipur. So the court recommended that speakers ordinarily decide disqualification petitions within 3 months. It also acknowledged that prolonged inaction on petitions is a mechanism to subvert the anti-defection law itself. Okay, nevertheless, more than 4 decades later, the law continues to generate intense political and 1985 का law है, but still it generates intense political constitutional debates. A brief overview of the prelude to the enactment of the law will help us understand the evolution of the law. So let us read the prelude to the enactment of the law. The period between 1967 and 1971, which is usually referred to as the era of instability or the coalition era. So 1967 to 1971, an era of instability during which 45 governments were formed and collapsed across various states because of frequent defections by legislators. Now, following the decline of one-party dominance after 1967 general elections, defection became a strategic tool to capture or topple governments. Legislators often shifted their allegiance not necessarily because of ideological disagreement but to secure ministerial offices or other material benefits. The resulting defections brought unprecedented political instability and weakened public faith in representative democracy. In this context, the Vaibi-Chavan Committee on Defections, very important. So, in this context, the Vaibi-Chavan Committee on Defections, 1969, it documented the extent of the problem and recommended several measures to address it. The committee defined defection as the voluntary giving up of allegiance to a voluntary part. So, this is very important. So, it defined defection as the voluntary giving up of allegiance to a political party on whose symbol a legislator had been elected, except when such action resulted from a decision of the party. Later, the Anti-Defection Law was envisaged as a mechanism to ensure that elected representatives remain accountable to the political mandate on which they were elected. Very important line, that elected representatives remain accountable to the political mandate on which they were elected. To achieve this objective, the law specifies grounds on which the legislators must be disqualified for defection. So, what constitutes defection? Under the 10th schedule, we have already read this, but just a slight good reading. So, the Anti-Defection Law applies to both members of the parliament and state legislatures. Under the 10th schedule, a legislator can be disqualified on the following grounds. If a member of a house voluntarily gives up membership of their political party. In Ravi S. Naik versus Union of India 1994, the Supreme Court held that voluntary giving up membership does not necessarily require a formal resignation by a legislator or to be disqualified under the Anti-Defection Law. The Apex Court observed, even in the absence of a formal resignation from membership, an inference can be drawn from the conduct of a member that he has voluntarily given up his membership of his political party to which he belongs. In other words, if a legislator does not tender a formal resignation from the party but involves themselves with another party, such as holding positions in another party, that would amount to voluntarily giving up membership and be grounds for disqualification. So, if a member votes or abstains from voting in a house contrary to the directions of the political party without prior permission, and such voting or abstention has not been condoned by the party within 15 days. If an independent member joins a political party after elections, and if a nominated member joins a political party after 6 months of taking their seats. Now, we already saw exceptions to the disqualification as well. We have seen the role of the speaker. Okay, we have seen all this. Let us just give this a quiet reading. So, the principal exception to disqualification of the 10th schedule is merger of parties. A legislator is protected from disqualification if at least 2/3 of the legislators of a party agree to merge with another political party. Originally, the 10th schedule also contained an exemption for a split, whereby 1/3 of the legislators could break away without attracting disqualification, but this provision was abused, leading to mass defections under the guise of internal factionalism. Now, the Constitution 91st Amendment Act of 2003 addressed this issue by removing the split exception entirely and retaining only the exceptions for mergers. And the same amendment also inserted Articles 75 Clause 1b, 164 Clause 1b, 361 Clause 1b to prevent defectors from being rewarded with ministerial offices and remunerative political posts until re-elected. However, the effectiveness of these safeguards significantly depends on the institutional mechanisms responsible for the implementation, and this draws attention to the role of the presiding officers. The role of the speaker. Now, para 6.1, very important, the 10th schedule, vests powers to decide disqualification petitions in the office of the presiding officer, the speaker or the chairman of the house, and their decision shall be final. Now, this reflects constitutional faith in the office of the speaker as an impartial constitutional authority which is capable of acting in a non-partisan manner. But practical experiences and allegations of political biases have at times raised concerns regarding the neutrality of presiding officers. Therefore, the effectiveness of the 10th schedule depends largely on the institutional integrity and political independence of the presiding officer. In addition, the timing of decisions on disqualification petitions has become a matter of political scrutiny. Now, the 10th schedule initially barred judicial review of the speaker's decision. Now, judicial review of speaker's decision, but in the Kihoto Hollohan versus Zachillhu 1992, the Supreme Court upheld the constitutional validity of the Anti-Defection Law while saying that the Speaker's decisions are subject to judicial review. The Apex Court observed that Speaker acts as a tribunal under the 10th schedule and judicial review remains part of the basic structure of the Constitution which cannot be bypassed. In Nabam Rebia versus Deputy Speaker 2016, the Supreme Court held that a speaker should not decide on disqualification petitions while notice seeking his or her removal is pending. This ruling significantly influenced disqualification proceedings. Also, the court has repeatedly emphasized the need for timely decisions in defection cases. In Keisham, Meghachandra, since Speaker Manipur Legislative Assembly, the court recommended that speakers ordinarily decide disqualification petitions within 3 months. Such judicial interventions reflect the growing concerns surrounding the timely resolution of disqualification proceedings and the implications for political stability. There are some post-reading questions which you can write down and see. So, what were the circumstances that led to the enactment of the Anti-Defection Law? Discuss its objectives and constitutional significance. What constitutes a defection under the 10th schedule of the Constitution? Explain the grounds of disqualifications and exceptions thereto. Why was the split exception under the 10th schedule removed by the 91st Constitutional Amendment Act 2003? Explain its implications. The Anti-Defection Law has enacted to curb the evil of political defections. To what extent has it succeeded in achieving this objective? Examine. The office of the Speaker has become the focal point of constitutional disputes under the 10th schedule, discussed with the help of relevant judicial decisions.